She leaned over at my own Thanksgiving table and whispered loud enough for everyone to hear, "He's worthless. Cut him off completely." My son just nodded. I folded my napkin, walked out, and by Friday, I'd transferred $2 million and rewritten my will. 112 missed calls by Sunday. They thought they'd inherit everything. They were wrong. Before continuing, subscribe to our new channel, where we tell stories about men who take revenge on their insolent children, sons-in-law, and daughters-in-law. My name is Walter Daniel Reed. I'm 68 years old, and I live in Charleston, South Carolina, a city that smells like saltwater and old money and keeps its secrets well. For 36 years, I was a licensed architect. I built things meant to last. Office buildings on East Bay, a hotel on the waterfront, a pediatric wing at MUSC still standing today. 4 years ago, I sold my firm and walked away. These days, I spend my mornings in Slip 7 at Pierce Wharf Marina, restoring a 1952 wooden ketch called the Clara May. She was a wreck when I found her. The work is slow. I don't mind slow. The way a man builds things tells you how he thinks. And what happened at my dinner table on Thanksgiving tells you everything about how my son Nathan and his wife, Stephanie, think. Nathan is 39. He graduated from Duke University. Full tuition, paid by me, and went into commercial real estate law. Smart kid. Genuinely smart. When he was small, he used to sit beside me at the drafting table and ask about load-bearing walls. "Why can't you just take that one out, Dad? It looks like it's just sitting there." I'd explain, "Some supports are invisible. You only know they mattered once they're gone." He doesn't ask those kinds of questions anymore. Stephanie came into the picture 6 years ago. She's 36, originally from Colombia. And she is, I'll give her this, genuinely striking. She runs an interior design blog, 47,000 followers. Lots of photographs of throw pillows and captions about curated living. She married Nathan 14 months after they met. That pace of decision-making should have told me something. They moved into 1847 Palmetto Bluff Drive 3 years ago. My house. The house I designed the addition to myself. Drew the plans by hand, supervised the framing, picked every window. They needed somewhere while they got on their feet. 3 years later, they're still getting. The rearranging started within weeks. I came home one Tuesday to find my garage reorganized. My lumber pushed to the wall, her car in the center. A little chalkboard sign said, "Organized chaos." She was very pleased. I moved the lumber back. We didn't discuss it. By the following August, she was calling the living room the common area and telling dinner guests that living with me was like sharing a house with a very opinionated museum. Everyone laughed. Nathan laughed loudest. I smiled. I noted the temperature of that smile and filed it away. I don't entirely blame my son. Nathan is not cruel. He's comfortable. Cruelty requires intention. Comfort just requires a couch and someone willing to make all the decisions. I've watched him shrink, incrementally, over 6 years. The way a building settles when the ground beneath it shifts. So slowly you don't notice, until a door won't close the way it used to. The last Thursday of November. I was up at 5:30, made coffee, started the duck. 4 hours, low and slow. Citrus brine I'd refined over 2 decades. I set the table myself. My mother's silver from Beaufort. A pressed linen tablecloth. The good napkins. White with a monogram. Mine says WR. My neighbor Rosalind Burns arrived at 2. She's 71, retired magistrate judge. Sharp as a box cutter. No family nearby. I have a spare chair. This has become our arrangement. She brought sweet potato casserole and improved the atmosphere simply by walking in. Nathan and Stephanie arrived 15 minutes later. Their son Cody, 4 years old, my grandson, was buckled into his car seat with a dump truck and a look of total self-satisfaction. I lifted him out myself. He smells like baby shampoo and crackers, and I will not pretend that doesn't matter to me. Dinner held together for the first hour, structurally sound, no visible cracks. Rosalind carried the table gracefully. I talked about the Clara May. Stephanie discussed a renovation she was consulting on in Mount Pleasant. Nathan ate and nodded and checked his phone once, which I noticed and said nothing about. Then the plates were cleared, and I was refilling wine glasses when Stephanie leaned toward Nathan. Not quite a whisper, the specific registers some people use when they want to be heard but want deniability. Audible confidence, perfectly calibrated. "He's worthless," she said. "Cut him off completely." The room went quiet, the kind of quiet that has texture and weight. I looked at Nathan. He looked at his plate. Then he picked up his fork, set it down again, and gave one small, deliberate nod. Rosalind's eyes found mine across the table. She said nothing. She didn't need to. I picked up my napkin, white linen, WR, and folded it into a clean rectangle. 4 corners aligned, set it beside my plate, stood up. thanked everyone for coming to my home, eating the duck I'd made, sitting at my table, said it pleasantly, meant every syllable. Then I walked to the back porch and closed the door behind me. The harbor was dark, 51 degrees, and I had no jacket. I stood there in the cold and did something I hadn't done in a long time. I smiled, not because anything was funny, because something had just become very, very clear. The Clara May has a small cabin below deck, a fold-out berth, a port light above it, the smell of sawdust and linseed oil that calms me more reliably than anything a doctor has suggested. I spent that night there, not from grief, from the need to think without an audience. I lay on the berth and did what I always do with a complex problem. I looked for the structure. Which elements were load-bearing, which were decorative? Where had someone already been quietly testing the walls? I thought about a Saturday 2 winters back. Nathan and I were working in the yard. I was pruning the live oak by the drive. He was leaning on the fence with a coffee, the way we used to exist comfortably in the same space without needing to perform it. He'd been talking through a deal that had collapsed, something raw and uncertain in his voice, the way he used to sound when he wanted to think out loud with someone he trusted. We worked through it together. I asked questions. He found his own answers. That was the last afternoon I can clearly remember when Nathan was entirely himself. I thought about the first time something felt wrong with Stephanie. A dinner, 4 months into their relationship. She'd reorganized my kitchen while I was in the shower. More functional, she explained, with the tone of someone doing me a favor. I pointed out that I knew where everything was. She smiled. That's not the same as it being right. Nathan laughed. Already the laugh was slightly too quick, slightly too complete. A man performing amusement for someone he's already working to impress. I told myself it was minor. I told myself I was being reasonable. What I underestimated was the compound effect. In architecture, the most dangerous buildings aren't the ones that look unstable. They're the ones that look fine. A hairline crack in the slab, an invisible shift in the grade. The house stands perfectly upright until the morning it simply doesn't. I'd been watching things move around me and calling it adaptation. I fell asleep around 2. I slept well. I suspect that says something about me. The next morning, I drove back to Palmetto Bluff Drive. The kitchen smelled like coffee. Later, poured coffee, studied the counter later, poured coffee, studied the counter. Did not look at me. I waited until he was settled. Then I looked at him directly, not with anger, just the full, quiet weight of a fact, and said, "Nathan, you know this house is titled in my name." Not a question, not a threat. The way you note a load-bearing wall before someone picks up a sledgehammer. His color changed, barely, but I've been reading structural responses for a long time. Stephanie's hand paused on her phone for 2 seconds exactly, then resumed. She didn't look up. I took my coffee to the study. Over the next 36 hours, I watched carefully. Stephanie made a phone call from the bedroom just after 10 that night, voice low. Nathan passed my study door twice the following morning without knocking. He had always knocked before. Always. I went through my documents methodically. Fire-rated cabinet. Second drawer. Living trust, pour-over will, investment account statements, the deed to the house, the partnership agreement from my minority, stake in Harbor Point development. Everything where it should be. Everything clean. Until the back of the second drawer. A co-signature agreement, 3 years old. Signed when Nathan was added to one of my investment accounts during a minor medical procedure. Routine at the time. Sensible. The kind of thing you do without much thought because you trust the person and the situation seems temporary. I read it again, slowly. The way you reread a contract when you think you may have missed something the first time. Nathan was listed as co-signer, not beneficiary, co-signer. In South Carolina, that distinction matters enormously, but the line is not without complexity. There are conditions under which a co-signer can argue a degree of entitlement. The argument would be difficult, not impossible. And Nathan is a lawyer who constructs arguments for a living, which is not a coincidence I can afford to ignore. Stephanie had shown no interest in my filing system in 3 years of living under this roof, but the 2-second pause in the call after 10, and the specific timing of what she'd said at my table. Not a burst of frustration, not an accident, a communication, a signal between 2 people who had already discussed what came next. She knew about that document, or someone had told her, and they had been waiting for circumstances to shift in their favor. I closed the drawer, poured the rest of my coffee down the sink. I wasn't angry. Anger builds poorly. What I felt was something colder and considerably more useful. The recognition that a man who understands how structures work also understands, precisely, how to dismantle them. What had happened at my dinner table the night before wasn't the beginning of something. It was the first visible mistake in a plan someone else had already drawn up. I put on my coat, picked up my keys. Marshall Cade's office was on Meeting Street, 4th floor. I had his address memorized. I had a great deal of things memorized. It was time to start building. I drove to the bank the next morning, the Friday after Thanksgiving, which meant the parking lot on Calhoun Street was half empty, and the branch manager, a careful young man named Patterson, was available without an appointment. I parked, went inside, and asked to speak with him directly. Not a teller. The manager, he came out in under 3 minutes. That's what happens when a man walks in wearing a good coat and asks calmly. I sat across from Patterson in his glass-walled office and explained what I needed. I had a joint investment account, one where my son Nathan was listed as co-signer. I wanted to transfer $2 million from that account into a new revocable trust under my name alone, the W.D. Reed Family Trust. I had the account numbers. I had my identification. I had because I had spent the previous evening reviewing my documents, with the specific attention of a man who now has a reason to be thorough, a clear understanding of every figure involved. Patterson asked a few routine questions. I answered them. He processed the transfer. The full balance of the account had been $2,340,000. I moved $2 million into the new trust. The remaining $340,000 I left untouched, partially for liquidity, partially because a man who moves every penny at once looks like a man acting in panic. I was not acting in panic. I shook Patterson's hand, thanked him, and walked back to my car. The whole thing took 41 minutes. There is a particular sensation that comes from doing something quietly significant, while the world continues around you at normal speed. Other people in that parking lot were buying groceries, arguing on phones, looking for spaces. None of them had any idea. I found that clarifying. I drove to 220 Meeting Street from the bank. Marshall Cade's office occupies the 4th floor, a suite that smells like printer paper and expensive coffee, and the particular brand of order that competent people maintain. His assistant showed me in without an appointment, which is the advantage of being someone's client for 11 years. Marshall is in his late 60s, keeps his suits pressed to a standard that suggests a prior military background, and communicates primarily through the arrangement of his silences. He's not warm. He doesn't need to be. He's precise, and precision is what I needed. I sat down, told him what had happened at Thanksgiving, not with emotion, with sequence, and told him what I'd done at the bank that morning. He listened without interrupting. When I finished, he straightened one of the pens on his desk by approximately 2 millimeters and said, "Tell me exactly what you want the new will to say." I told him, "Nathan removed as direct beneficiary. The house and all remaining assets placed into the trust. Cody, my grandson, 4 years old, named as the trust's primary beneficiary, with distribution at age 25, conditional on completing a 4-year degree and having no felony convictions. 3 Charleston area charitable foundations, named as secondary beneficiaries for any portion Cody did not receive." Marshall wrote. His handwriting is small and perfectly level, which I have always respected. When I finished, he looked up and said, "You understand, this can be challenged." "That's why I came on a Friday," I said, "and not a Monday." He almost smiled. Marshall's almost smiles are as close to warm as he gets, and I'll take them. We spent the next 2 hours going through the language of the new will, with the kind of care that makes challenges difficult. Not impossible, nothing is, but difficult. By the time we were done, the document was airtight in the places that mattered, and I had signed it in front of 2 witnesses his assistant produced from the hallway. The new trust registration went through at 3:47 that afternoon. Marshall confirmed it by text. No commentary. Just the timestamp and the trust number. That's his way. I sat in my car outside his building for a few minutes. The afternoon light in Charleston that time of year has a quality I've always liked. Low and amber, the kind that makes the old buildings on Meeting Street look exactly as old as they are. My phone had vibrated 14 times during the 2 hours in Marshall's office. I checked it in the car. Nathan. 11 calls. 3 from a number I didn't recognize that turned out, when I looked it up later, to be a Charleston exchange associated with a law firm on Broad Street. I put the phone in my coat pocket without calling back. Then I drove home to have dinner in my own house and to wait for whatever came next, because something always comes next, and a man who has prepared his foundation doesn't need to be afraid of weather. I should mention that by the time I turned on to Palmetto Bluff Drive that evening, I had begun thinking about the co-signer document again. It sat in my mind the way a structural anomaly sits in a blueprint, something that doesn't announce itself as a problem until you understand the load it was designed to carry. Nathan had been added to that account for a practical reason, at a moment when practical reasons seemed sufficient. 3 years ago, I was coming out of a minor procedure. Administrative details needed managing, and adding him as co-signer was the simplest solution available. I'd trusted the arrangement the way you trust a beam that's always held weight, but now I was standing at a different angle, looking at the same beam, and I could see what I hadn't seen before. The arrangement hadn't been kept in place out of convenience. It had been left there carefully because someone was planning to use it. A co-signer with access to $2 million, combined with a will naming Nathan as direct beneficiary, that was leverage. Not the dramatic kind. The quiet, administrative kind that operates through paperwork and patience, and the assumption that an aging man won't look too closely at his own documents. I parked in the garage, sat for a moment in the dark with the engine off. The scaffolding was already up around me. That was fine. I'd spent my entire career building things inside scaffolding. The question now was not whether they had a plan. It was how far along that plan had gotten while I was busy being reasonable, and whether there were parts of it I still hadn't found. I want to go back to the napkin. White linen, monogram WR, made by my mother in the winter of 1987 when she was living in Beaufort, and had taken up embroidery as something to do with her hands during the evenings. She made 6 of them. I still have 4. I used them at the table the way she intended. Not saved for occasions, but used, laundered, ironed flat, used again. That's how you honor something made by hand. You use it. When I folded that napkin at the table on Thanksgiving, I was thinking about a specific principle I learned early in my career. You never demolish a load-bearing wall from emotion. You remove it from calculation after you have verified that the structure above it is properly supported and that the removal is part of a deliberate plan. Emotion makes you pull without looking. Calculation makes you pull at the exact right moment. The transfer of $2 million was not revenge. Revenge is what you want to do immediately, which is why it almost never works. What I did on that Friday was more like a controlled demolition. I identified one critical support that Nathan and Stephanie were depending on. Access to those funds, either through cosigner authority or through inheritance, and I removed it cleanly, legally, and without announcement. Marshall had confirmed what I suspected. Because Nathan was a cosigner and not a named beneficiary, he had no legal claim to the funds themselves. Cosigner status grants access for management purposes, not ownership. The transfer was entirely within my rights. The new W.D. Reed Family Trust was registered and fully valid under South Carolina law. The will was equally clean. I was of sound mind. Marshall had 2 attorneys present as witnesses, and the documentation of the meeting itself served as contemporaneous evidence of competence. Nathan could challenge it. He'd need to prove I was acting under duress or diminished capacity. He would not be able to prove either, because neither was true. I drove home at 5:30 and pulled into the garage. Stephanie was in the front hallway when I came through the kitchen. She had a particular look, the one she deploys when she wants to appear casual, and has rehearsed it slightly too much. She was holding a dishcloth, which was a prop. I've never once seen Stephanie use a dishcloth for its actual purpose. "Where were you all day?" she asked. Light, curious, the tone of someone asking an idle question rather than a surveillance question. "Filing paperwork," I said. I watched her process that. The word paperwork landed somewhere behind her eyes, and she turned it over for half a second before deciding it was innocuous. She let it go. She said something about dinner, and I said I wasn't hungry, and I went to my study. That evening I sat at my desk and counted the calls on my phone. By midnight Sunday I would reach 112, 74 from Nathan, 38 from Stephanie. I read each notification without opening it. I was not ready to speak to either of them, and more importantly, I did not need to be. Nothing they could say would change the documents already signed and registered. The situation had already changed. They didn't know it yet. I spent Saturday and Sunday at the marina. Partly because the Clara May needed attention, I'd been fitting new planking along the starboard bow, and the epoxy required careful monitoring at this stage. Partly because the marina is a place where my phone receives calls, but I am not required to feel any urgency about them. The water has a way of establishing correct proportions. On land, unanswered calls feel enormous. On a wooden boat that smells of sawdust in the Cooper River, they feel exactly the size they are. I thought, between checks on the epoxy, about what I didn't yet know. I knew what I'd done. I knew the documents were sound. What I didn't know was the full shape of what Nathan and Stephanie had been planning. How far it had progressed, who else was involved, what timeline they were working toward. The co-signature agreement I'd found in my desk had been the visible part. In my experience, visible parts of plans are rarely the whole plan. Monday morning, I called Marshall at 8 o'clock. He picked up on the second ring. I told him what I'd found in my desk, the cosigner document signed 3 years ago. I told him about Stephanie's phone call at 10:14 on the night after Thanksgiving, and Nathan's 2 passes by my study door without knocking. I told him I suspected there was more architecture to what they were doing than I could see from the outside. Marshall was quiet for a moment. Then he said, "You need someone who does this professionally." He gave me a name, Diana Foster, former detective with the Charleston County Sheriff's Office. 14 years on the job, last several in financial crimes. Now private, office on King Street. Not his friend, a professional he'd worked with on 2 previous estate matters where asset tracing had been necessary. I called her office before 9. Her assistant scheduled me for that afternoon. Diana Foster's office on King Street is on the 2nd floor above a framing shop, reached by a narrow staircase that smells like sawdust from below and old carpet from above. She's 44, compact, with the specific kind of stillness that comes from years of watching people rather than performing for them. She shook my hand once, sat down, and opened a legal pad. I explained the situation from the beginning. Thanksgiving, the napkin, the cosigner document, the calls. I did not editorialize. I gave her sequence and facts, and let her draw her own conclusions. When I finished, she tapped her pen once on the pad and said, "What do you want to know?" "Everything they've been doing that I don't know about," I said. "Financial picture, accounts, debts, any agreements they've signed that involve my property or my assets." She wrote for a moment, then, "Give me 72 hours. I walked back to my car and sat with the engine idling, looking at the brick facade of the building I'd just left. 72 hours. Whatever Diana found, I would be ready for it. And whatever shape their plan had taken, whatever scaffolding they'd built while I was busy being a reasonable man, I was about to see the whole structure for the first time. The young man at my front door that Sunday evening was wearing a suit that cost more than he was comfortable in. He held a manila envelope with both hands, the way people hold things they've been told are important, and he introduced himself as an assistant at the firm of Caldwell and Price on Broad Street. I thanked him for coming on a Sunday, which seemed to unsettle him slightly, and I took the envelope. Inside was a 3-page letter on firm letterhead. The language was careful and formal, and built around a phrase that Nathan, and I say Nathan because Stephanie doesn't have the legal vocabulary, but she had certainly approved every word, had chosen with precision, wrongful redistribution of jointly managed family assets. The letter did not file a claim. It announced the intention to file one, contingent on my response within 10 business days. It cited the cosigner agreement. It cited the transfer of $2 million. It strongly implied that a man of 68, who had moved that amount of money 2 days after a family argument, might be exhibiting signs of diminished capacity and undue emotional distress. I read it twice. Then I set it on my desk, next to the cosigner agreement I'd found 2 days before, and I sat in my chair and looked at the 2 documents side by side. 112 calls. I went back and counted them properly. 74 from Nathan's cell, 38 from Stephanie's. The calls had started the day of the transfer and ended sometime Sunday evening, roughly around the time this young man in the uncomfortable suit had presumably left their legal counsel's office with an envelope. 112 calls is not the behavior of a family that wants to talk. It is the behavior of people who want to establish for the record that they tried to reach me, that they were reasonable, that I was the one who went silent. I found that almost admirable in its thoroughness. Almost. That Monday morning at 8 o'clock I called Marshall. He listened to my description of the letter without interrupting, then said, "They have no viable claim. The account was titled in your name. Nathan's cosigner status conveyed access, not ownership. The transfer was lawful." "I know that," I said. "What they're doing," Marshall continued with the measured pace of a man who has explained this before, "is creating friction. A lawsuit doesn't need to succeed to cost you time, money, and attention. They may be betting that you'll settle rather than litigate. They would be wrong about that." A pause. "Then here is what I recommend. We don't respond to the letter with anything that gives them material. We respond with a single sentence acknowledging receipt, and then we move to the next step before they do." "What's the next step?" "You tell me what you haven't told me yet," he said, "because I suspect there's more." There was more. I told him about the cosigner agreement, about Stephanie's phone call, about the pattern I'd been assembling. I told him I'd hired Diana Foster and that she was 72 hours into her work. Marshall listened, then said what I had already decided. "Wait for her report. Don't respond to the letter until we know what she finds." I spent those 72 hours at the marina, working and thinking in approximately equal measure. The Clara May's starboard bow planking needed attention. I'd been applying epoxy in stages, and this was the part of restoration that requires patience above everything else. You cannot rush cured wood. You cannot persuade it. You work with the grain or you work against it, and working against it costs you more than you saved. I thought about patience while I worked, about the difference between reacting and responding. Nathan had been trained as a lawyer, which means he was trained to move fast and create facts on the ground before the other party can organize. The letter was exactly that, a flag planted before I'd thought to bring my own. What he hadn't accounted for was that I had already planted mine 2 days earlier, quietly, at a bank on Calhoun Street and a law office on Meeting Street. On the third day, Diana Foster called. Her voice, when she has something significant to tell you, takes on the specific quality of a person choosing their words with care. Not slowly, carefully. There's a difference. I've noticed it in good attorneys, in surgeons, in structural engineers, reading a report they don't entirely like. The information is already there. The pause is for the delivery. "Mr. Reed," she said, "there's something about your house you need to know. Can you come in?" I was at her office on King Street within the hour. The narrow staircase above the framing shop, the smell of old carpet, the second-floor room with the legal pad and the pen that Diana tapped exactly once when she was done listening. I'd been here twice now and already understood the rhythm of the place. She had one document on the desk, face down. She waited until I'd sat and she'd closed the door. Then she turned it over. I looked at it, and for the first time since Thanksgiving, something shifted in my chest. Not fear exactly. The particular alertness of a man who has just confirmed that his suspicion was not paranoia, that the pattern was real, that the scaffolding around him was exactly as load-bearing as he'd feared. Diana Foster's desk, when I arrived, had a single printed document on it, 1 page, face down. She turned it over after I sat, and she had closed the door. It was a listing agreement, the kind a seller signs with a real estate agency when they're ready to move a property. The property listed was 1847 Palmetto Bluff Drive. The seller of record was Nathan Allen Reed. I looked at the document for a long moment. The agency was Sullivan and Marsh, a firm I recognized. Mid-market residential, offices on Coleman Boulevard. The estimated listing price was $1,780,000. The agreement had been signed 6 weeks before Thanksgiving. "He can't sell that house," I said. My voice was even. I was making sure of it. "No," Diana said, "but the agreement was signed under a clause that made it contingent on either your death or a change in the residential occupancy arrangement." She let that sit. Someone advised him on the language. It was drafted carefully. I asked the question I needed to ask. "When exactly?" She turned the page and pointed to the date at the bottom. 6 weeks before Thanksgiving. 5 weeks and 4 days before Stephanie leaned across my dinner table and said what she said. I sat back in my chair. The phrase at dinner had not been a moment of contempt getting loose. It had been a scheduled announcement. Stephanie had looked at Nathan and told him, in a room with witnesses, clearly enough to be heard, that it was time to move, that the waiting was done. They had a listing agreement. They had a legal theory via the co-signer document. All they needed was for me to do something rash, or to die, or to be persuaded that I was no longer welcome in my own life. 68 years old, my own table, my own duck. I became very quiet for a moment. Diana, who had spent 14 years watching people absorb difficult information, let me be quiet. "There's a problem for you as well," she said when I looked up. "The house is titled in your name personally, not in any trust. If Nathan files his claim and argues financial incompetence, a court could theoretically freeze asset transfers pending review, including the trust you've already established." I had anticipated something like this. Not this exactly, but something. How long would a freeze last? Months, possibly. Long enough to be a significant obstruction. I called Marshall from the car outside Diana's office. I told him what she'd found. He was quiet for 3 seconds, which, for Marshall, is the equivalent of a sharp intake of breath. And then he said, "The house needs to go into a trust immediately. A qualified personal residence trust. You retain the right to live there for a defined term. After that term, ownership transfers to a charitable beneficiary. It puts the property beyond the reach of any civil claim. How long does it take?" 3 weeks, $8,400 in legal fees. "Start Monday," I said. I drove home. Stephanie was in the kitchen when I came through the back, standing at the counter the way she does when she wants to appear occupied, but is actually watching. She had arranged herself very specifically. Relaxed posture, casual task, and it was the arrangement of a woman who had been waiting for my car to pull in. "There you are," she said, warm, easy. I put my keys on the hook and said nothing. 3 days into the QPRT paperwork, she came to my study door in the afternoon with 2 mugs of coffee and an expression that she had clearly rehearsed into something that resembled sincerity. She asked if we could talk. I said yes, because I wanted to hear what she would say, and because South Carolina is a one-party consent state, meaning I can record any conversation I am a party to, without informing the other person. I had already decided to consent. I took the coffee. I sat. She talked for 22 minutes. She talked about how hard it had been to integrate into this family, about feeling unwelcome, about the distance she perceived from me, about how what I had done with the accounts had made her and Nathan feel abandoned and targeted. She spoke with genuine fluency. This was a woman who had thought carefully about what she wanted on the record. She said the words bridge and heal and going forward, and managed to make each one sound like a reasonable request. She did not say anything about the listing agreement. She did not say anything about the law firm on Broad Street. She did not say anything about the 112 phone calls. When she finished, she waited. She was watching for something, a reaction, an opening, some indication that I could be redirected. I gave her nothing. I said I appreciated her sharing that, and I thanked her for the coffee. After she left, I took the small digital recorder from my coat pocket and checked the indicator light. 41 minutes of storage remaining. 22 minutes recorded. I set it on my desk next to the cosigner agreement, and the listing agreement, and the letter from Caldwell and Price, and I looked at the 4 items arranged in a neat row. A man who designs buildings learns something early. The most important work happens before anything is visible. The excavation, the foundation, the framing that will eventually be covered by walls. By the time the structure is recognizable, the hardest decisions have already been made. The QPRT paperwork was moving. The new will was filed. The trust was registered. And now I had 22 minutes of a very articulate woman explaining, in her own voice, that she was operating from a position of injury while simultaneously executing a real estate listing agreement on a property she did not own. Marshall had told me, move before they do. I had moved, quietly, legally, and in the correct order. Outside, the Cooper River was dark and still. Somewhere in Slip 7, the Clara May was waiting for me to finish one job before returning to the other. I wasn't finished yet. The QPRT paperwork was completed 3 weeks after I started it, exactly as Marshall had projected. He called me on a Wednesday morning, not a text, a call, which from Marshall means the news is worth the formality, and told me the Qualified Personal Residence Trust for 1847 Palmetto Bluff Drive had been recorded with the Charleston County Register of Deeds. The house was no longer in my name personally. It was in a trust. I was listed as the sole beneficiary, with exclusive right of occupancy for a term of 7 years. After that term, ownership would transfer to 3 Charleston charitable foundations, with a directed payment of $200,000 to the W.D. Reed Family Trust, earmarked for Cody when he turned 25. What this meant in practical terms, the house was now outside the reach of any civil judgment against me. Nathan could win every lawsuit he filed, and he still could not touch the property. The listing agreement with Sullivan and Marsh was, as of that morning, worth exactly as much as the paper it was printed on. I thanked Marshall, hung up, and went to the kitchen to make coffee. Nathan was in the living room when I passed through, laptop open, doing something with documents. He glanced up. I noticed his eyes go to my face for a fraction of a second, reading me the way lawyers read rooms, and find nothing useful there. I nodded and continued to the kitchen. That afternoon, an envelope arrived by courier. Marshall called simultaneously. Nathan's attorney had filed the formal complaint with the Charleston County Court of Common Pleas. 2 counts. First, wrongful redistribution of jointly managed family assets. Second, diminished capacity affecting sound financial decision-making. I read the complaint that evening. It was well drafted, I'll give them that. The diminished capacity argument was built around 3 things: the speed of the transfer, the timing relative to a family conflict, and the assertion that a man acting with full competence would not have moved $2 million within 48 hours of an argument. The argument was almost persuasive, which is the only kind worth making. I noted for the record that Nathan was a lawyer who understood how to draft a complaint designed to be difficult to dismiss quickly. The diminished capacity count, in particular, was strategic. It did not need to succeed at trial to be useful. It only needed to create enough uncertainty to motivate a settlement. A judge might appoint a guardian ad litem to review my finances pending the hearing. That could freeze the trust transfer review. That could cost months. Nathan knew this. Whoever had advised him on the strategy understood exactly what the procedural friction would accomplish, even if the underlying argument failed. It was, I thought, a well-constructed trap, the kind that works on a man who acts impulsively, settles quickly, or has something to hide. I did not act impulsively. I had no inclination to settle on terms I hadn't chosen, and my documents were cleaner than the complaint suggested. What Nathan did not know, could not know because the QPRT filing had happened that same morning and public records take several days to update, was that while his attorney was finalizing the complaint, the house had already moved beyond his reach. By the time he discovered that, the recording would be an immovable fact in the county register. Marshall and I filed the acknowledgement of the complaint the following day, one sentence, and then filed our counterclaim the day after that. The counterclaim was specific: unauthorized use of real property. Nathan and Stephanie had occupied 4 rooms of a 4,800 square foot house for 38 months, without a lease, without a rental agreement, and without contributing to utilities, property taxes, insurance, or maintenance. Marshall calculated the fair market rental rate for comparable properties in the Chestnut Hill neighborhood, $1,770 per month. 38 months at that rate, $67,260. We rounded to $67,200 as a courtesy. We also filed the first notice of termination of residential license, the legal mechanism for removing an occupant who has no formal tenancy agreement, giving them 60 days. I asked Marshall to have the notice served personally, at the house, during business hours. I was in my study when it happened. I heard the door. I heard Stephanie's voice shift. Not the words, just the particular register that changes when something unexpected has occurred and the performer has not yet decided how to respond. Then silence. Then heels on hardwood, moving quickly toward Nathan's home office. I did not go to the hallway. I returned to the document I had been reading. That evening, Rosalind Burns texted me. "Your son's car has been in the driveway 2 hours with the engine running. Everything all right?" I replied. "Fine. He's thinking." That night, Diana Foster sent a text at 10 o'clock. Check account at Truist Bank under S. Collins Reed. Balance $340,000. Source is not Nathan. I read it twice. Then I put the phone face down on my desk and looked at the ceiling for a long moment, thinking about the particular architecture of a plan that had been running alongside mine for 3 years, without my knowledge. I met Diana at her office the following morning. She had several pages on the desk and a legal pad with numbers in columns. The $340,000 had accumulated over roughly 2 years in regular deposits, between $18,000 and $22,000, all originating from a business account belonging to an LLC called SC Home Consult Group, registered in South Carolina. The registered director was Stephanie Collins Reed. The listed business purpose was interior design consulting. "Her blog," I said. "Some of it," Diana said. 14 clients paid SC Home Consult Group over 2 years. 8 of those 14 are business partners, or principals at Sullivan and Marsh. Sullivan and Marsh. The firm holding the listing agreement on my house, signed by Nathan, contingent on my death or departure. I sat with that for a moment, not from shock, but from a kind of cold recognition. The people positioned to earn a sales commission on my house had also been paying my daughter-in-law for consulting services for 2 years, while she lived in the house they were planning to sell. "Is it illegal?" I asked. "Not inherently," Diana said. "But if those payments were made in anticipation of a specific future transaction, and if the income wasn't fully reported, a competent attorney could raise both a conflict of interest argument in civil court and a separate question for the Department of Revenue." I called Marshall from the car. He listened, then said what I expected. Within our civil case, we could subpoena Stephanie's business records. Everything would enter the public record of the Charleston County Court. Every payment, every client, every transaction. And separately, entirely separately, any citizen can provide information about potentially unreported income to the South Carolina Department of Revenue. That process would run on its own clock. I noted that. Then I did something I had not done since Thanksgiving. I called Nathan. He picked up on the 4th ring. His voice was the voice of a man who had been anticipating this call for weeks and had still not prepared for it. "Nathan," I said, "I know about the account. I know about SC Home Consult Group. I know about Sullivan and Marsh." One beat. "Talk to Marshall Cade before the hearing, if you want to limit what becomes part of the public record." 5 seconds of silence. "Dad, I can explain." I hung up, not from anger, because the call had done what it needed to do. He knew the full dimensions of what I knew, and what he chose to do with that information was his own decision. I had given him the door. The rest was his. The days that followed moved on 2 tracks. Marshall built our formal response to the complaint, a comprehensive filing that included the QPRT recording, the complete transaction audit for the trust transfer, and the attendance notes from the 2 attorney signing session, which served as contemporaneous evidence of sound mind and deliberate intent. Diana, meanwhile, confirmed 2 additional facts. Nathan carried a personal line of credit with $94,000 outstanding, and his firm's quarterly billing had declined 17% in the last reported period. They needed the assets. That was always the explanation, not malice as a thing unto itself. Malice in service of a financial shortfall they hadn't told me about, and a lifestyle that required a solution they were not willing to earn. 4 days before the scheduled hearing, a settlement proposal arrived from Caldwell and Price. Nathan would withdraw the diminished capacity claim if I agreed to 3 things: restore him as a 25% beneficiary of the W.D. Reed Family Trust, extend their right of residence by 12 months, and, this paragraph had Stephanie's fingerprints on every word, agree to a joint statement describing the Thanksgiving incident as a private family misunderstanding with no financial implications for any party. In other words, I would undo most of what I had done, and in exchange, they would stop doing what they were doing. I read it twice, set it on my desk next to the recorder, the listing agreement, the co-signer document, and Diana's report. 5 documents in a neat row. The complete structure of a 3-year plan, visible at last in its proper sequence. I called Marshall. "Counteroffer," I said. "They vacate voluntarily by April 1st. They sign a mutual release. Nathan remains excluded from the trust. Cody's beneficiary status is unchanged and untouchable." I paused. "That's the only offer I'm making." "Stephanie won't accept those terms?" Marshall said. "She won't," I agreed. "But Nathan might, when he finally reads the documents in front of him instead of the ones she's been handing him." "And if they don't accept?" "Then we go before Judge Taylor," I said, "and everything enters the public record, including the account, including the clients, including the LLC." I set the phone down. Outside, the Cooper River was dark and still. The counteroffer would be delivered the following morning. The hearing was 4 days away. Nathan had been a smart kid once, the kind who asked good questions about load-bearing walls. I had never stopped believing that somewhere underneath the last 6 years of comfortable compliance, that person still existed. I wasn't counting on it, but I hadn't stopped believing it either. There's a difference, and it matters. The settlement proposal from Caldwell and Price sat on my desk for 24 hours. Marshall had told me to take my time. I didn't need time. I needed the 24 hours to be on the record, so that no one could later argue I had acted impulsively. On the morning of the 2nd day, I called Marshall and gave him my counteroffer. The terms were simple. Nathan and Stephanie would vacate 1847 Palmetto Bluff Drive voluntarily by the 1st day of April. They would sign a mutual release. No further claims from either side. No litigation. No appeals. Nathan would remain excluded from the W.D. Reed Family Trust entirely. Cody's beneficiary status, $1,400,000 at age 25, contingent on a university degree and no felony convictions, would remain unchanged and untouchable. I would, in exchange, withdraw my counterclaim for the $67,200 in unpaid occupancy costs, provided Nathan signed a promissory note for $42,000, a reduction I considered more than fair. Payable at $700 per month over 5 years. Those were the terms. All of them. Marshall relayed the counter the same afternoon. The response from Caldwell and Price came the following morning. Stephanie, through her attorney, rejected it. Nathan, notably, did not respond separately. He had gone quiet in a way that was different from his earlier silences. Less strategic, more like a man trying to figure out which room he was actually standing in. 2 days passed, then a third. On the 4th day, the hearing was 1 week away. Marshall called me that afternoon with a specific tone I had learned to read over 11 years, the tone of a man who has new information and is organizing it as he speaks. "Nathan's attorney contacted me directly," he said. "Nathan wants to meet, without Stephanie present." I sat with that for a moment. "Where?" I asked. "He suggested your office. I told him you no longer have an office. He suggested coffee. I suggested my conference room." "Fine," I said. "Set it." The meeting was 2 days before the hearing. Nathan came alone, which told me more than anything he said in the first 10 minutes. He looked like a man who had not been sleeping well, and not in the theatrical way people sometimes perform sleeplessness to generate sympathy, but in the specific way of someone whose thoughts have been too loud for several consecutive weeks. His hair was neat, His jacket was pressed, but his eyes had the quality of a man who had been reading documents at 2 in the morning and not liking what he found. He sat across from me at Marshall's conference table and looked at his hands for a moment before he spoke. I noticed the particular stillness of someone who has spent days deciding what to say first and has not settled on it until this moment. I had not been in the same room as Nathan since Thanksgiving. 4 months. In that time we had communicated exclusively through attorneys, through a process server at my front door, and through one phone call I had ended after 14 seconds. Sitting across a conference table from him now, I was struck by how much older he looked. Not in years, but in the specific way a person ages when they have been carrying something they should have put down a long time ago. "I didn't know about the listing agreement," he said. "Not until after Thanksgiving. She showed it to me as she called it a contingency plan, something she'd arranged in case things went a certain way." "A contingency plan for my death," I said. He didn't flinch, which I respected. "Or for you choosing to live somewhere else." She framed it that way. "And the account at Truist?" A pause. "I knew she had income from the blog. I didn't know about the LLC. I didn't know about Sullivan and Marsh." He looked up. "I know how that sounds." It sounded exactly like what it was. A man who had been comfortable letting someone else make the decisions, and was now sitting across from the consequences. I did not say that. I let the silence hold its own weight. "What do you want, Nathan?" I said finally. He straightened slightly, the way lawyers straighten when they are about to say something prepared. "I want to accept your terms. All of them. I want to sign the mutual release. I want Cody's trust to stay exactly as you wrote it." He paused. "I want this to stop." I looked at him for a long moment. The kid who used to ask about load-bearing walls. The kid who had sat beside me at a drafting table with genuine curiosity about how things held together. Somewhere in the last 6 years, that person had walked into a room and let someone else rearrange all the furniture. "You understand Cody stays in the trust on my original terms?" I said. "Not yours, not Stephanie's. Mine." "Yes." "And the promissory note, 42,000 at 700 a month." "Yes." I nodded once. "Talk to Marshall." I left the conference room and took the elevator down to Meeting Street. It was a cold afternoon, the kind where the light came off the harbor at a low angle and made everything look like a photograph of itself. I walked to my car and sat for a few minutes without starting it. The hearing was in 2 days. Stephanie still had her own attorney. She had not agreed to anything, but the structure had already decided the outcome, the way structures always do, long before anyone picks up a hammer. The hearing before Judge Taylor of the Charleston County Court of Common Pleas lasted 3 hours and 40 minutes. I am going to tell you what it looked like from where I was sitting. Marshall presented 4 exhibits: the full transaction audit for the trust transfer, the competency documentation from the signing session, the QPRT recording filed with the county register, and the bank certification confirming that Nathan's co-signer status had never conferred ownership. By the time Marshall reached the 4th exhibit, the plaintiff's attorney, a capable man named Hess from Caldwell and Price, had the expression of someone identifying the exact moment a case had become structural. Nathan did not look at me once during the presentation. Stephanie sat beside him. Dark blazer, composed posture, the exterior she deploys when performing reasonableness in public. She held it for 40 minutes. I can tell you the precise moment it shifted. When Marshall placed the 4th exhibit on the record, Stephanie's left hand, flat on the table, closed into a fist, then opened. Then her chin lifted by approximately half an inch, the way a person lifts their chin when a recalculation returns a worse number than expected. Hess argued professionally, the diminished capacity claim, unsupported by medical evidence and countered by Marshall's competency documentation, did not survive contact with the actual record. Judge Taylor asked 3 questions and then arranged his expression into the specific neutrality of a judge who has already decided and is completing the procedural arrival. The ruling took 20 minutes to read aloud. The wrongful redistribution claim, dismissed. The diminished capacity claim, dismissed. My counterclaim for unauthorized use of residential property, sustained. The order, Nathan and Stephanie Reed were to vacate 1,847 Palmetto Bluff Drive on or before the last day of March. Nathan sat very still. Stephanie did not. Her composure, which had held through nearly 4 hours of a hearing that dismantled 2 years of planning one exhibit at a time, finally expressed itself. Not loudly, but as Judge Taylor finished reading, she turned her head and looked at me across the courtroom, and her face had the expression of a person who has just confirmed that the building they plan to move into belongs to someone else's charitable trust, and always will. The room began to empty. In the hallway, as I was putting on my coat, Stephanie appeared at my elbow. She had recovered most of her surface composure. Her voice was quiet, the voice she uses when she wants something to last. "You'll regret this," she said. I buttoned the top button and looked at her directly. "Stephanie," I said, "I spent 36 years building things meant to outlast me. I always know when a structure isn't viable." She held my gaze for 2 seconds. Then she walked toward the elevator where Nathan was waiting, his coat already on, his expression that of a man who had signed the mutual release and promissory note in Marshall's conference room the previous evening, before any of this had happened. The paperwork was already filed. I watched them go. Stephanie was talking. Nathan was not responding. That was, in its small way, the first genuinely hopeful thing I had observed in 6 years. The last day of March was a Tuesday. I was on the front porch with coffee when the moving truck pulled up at 8. Stephanie directed from the doorway. Nathan carried boxes himself. His idea, I suspected, not hers. Cody came out at 9:15 in his small jacket, holding the stuffed bear I had given him at Christmas. He walked across the porch and hugged my leg without saying anything. I crouched down, told him I would see him soon. He nodded with the particular seriousness of a 4-year-old who understands the weight of something without understanding its contents. Nathan's car pulled around the drive. Cody was buckled in. I stood on the porch of 1847 Palmetto Bluff Drive and watched until the car turned off the drive and was gone. What remained when the driveway was empty? $2 million in the W.D. Reed Family Trust, untouched. The house in the QPRT, outside the reach of any future claim. Cody's $1,400,000 at 25, conditions unchanged. The promissory note for $42,000 at $700 per month, signed and filed. And a voluntary disclosure I had submitted to the South Carolina Department of Revenue after the hearing. Documents describing the financial history of SC Home Consult Group and its relationship with Sullivan and Marsh. What the department chose to do with that information was their own business entirely. 3 weeks later, I was at Slip 7, working the final seams along the Clara May's bow with a putty knife, the kind of work that requires patience, a steady hand, and an absolute refusal to rush what isn't ready. Rosalind came down the dock with a pie tin covered in foil and the expression of a woman who has been following a situation closely and has formed conclusions. "Well," she said, "how are you?" I set down the putty knife. "You know, Rosalind," I said, "you can't build anything that lasts on ground that hasn't been properly prepared. Sometimes you have to clear the site before you can start." She studied me the way a retired magistrate studies a statement she finds mostly accurate, then set the pie tin on the bench beside her. I poured coffee from my thermos and looked out at the harbor. The phone in my pocket was quiet. The Clara May smelled of fresh sawdust and marine varnish. The harbor was bright and still. There was nothing left unfinished that needed my attention today. It was a fine morning to be 68 years old in Charleston, South Carolina. If you like this story, please like this video, subscribe to the channel, and share your impressions of this story in the comments. To listen to the next story, click on the box on the left. Thank you for watching.